Welcome back to Supreme Myths. My guest today is my close friend and law professor extraordinaire, Corinna Barrett Lain, who is the S.D. Roberts and Sandra Moore, it's a cool name, professor of law at the University of Richmond. Corinna went to William & Mary and then UVA. She clerked for the 10th Circuit. She worked as an assistant Commonwealth attorney in Virginia. I think I had that right. She's been teaching at Richmond since 2002. She is a member of the prestigious American Law Institute, and she is a wonderful person to boot. Welcome to Supreme Myths.
Oh, it's such a pleasure to be here. It's a real honor.
So we're going to talk about something today that I know really very little about because of this bizarre separation we have in constitutional law between criminal procedure type issues and the 4th, 5th, 6th, 8th Amendments and equal protection, due process, and everything else. I don't teach any criminal law stuff. So we are going to learn about the death penalty, which is your expertise. So one of your many expertises. So why don't you just start by telling us where did this interest come from in the death penalty? Because you've really done amazing
Where
work.
did the interest come from?
Yeah.
Oh, that's a great question to get us started. So you'll appreciate this because you and I are both con law scholars.
Yeah.
And so I was doing pieces. One of my earliest pieces was a piece looking at the role of the Supreme Court. And at UVA, I studied under Mike Klarman, one of
my heroes.
Right? There you go.
Yeah.
And I remember I actually took his constitutional history class in law school because it fit within my schedule. Then I learned to love it. But, that's sort of where that started. And one of my early pieces was really looking at the Supreme Court. And I kind of went back to civics class in high school where, I learned about the Supreme Court being this counter-majoritarian hero, the protector of unpopular minorities against oppressive majorities. And Mike Klarman's work had said, that's just not true. It wasn't true in Brown. And as a young law professor, I thought, well, it's the same narrative that we have in criminal procedure. This is the story of Miranda. This is the story of Mapp. This is the story of Katz and Terry versus Ohio and Gideon and all the greats. And I thought, I wonder if it's really true. And so I set out to do a legal history piece on those cases, on the giants of the criminal procedure revolution, and I did. And showed that
for non-lawyers listening, the cases you just mentioned, go through just real quickly what Mapp and Miranda and all those cases were real quick, because everybody knows about them, but just real quick what those cases said.
Yeah. Okay. So the criminal procedure revolution is from the 1960s.
Yep.
It's launched with Mapp versus Ohio. It's an exclusionary rule case that the court incorporates. It's the first incorporation case. The court incorporates the Fourth Amendment to the states. That's 1961. In 1963, we have Gideon versus Wainwright. The court incorporates the right to counsel. That's 63 and 66. We have Miranda versus Arizona.
Everybody knows
of course,
that
that's
one.
famous. Everybody knows that one. In 1967, we have Katz versus United States. And in that, the court sets the cornerstone of Fourth Amendment law as reasonable expectation of privacy. And then in 1968, we have Terry versus Ohio with stop and frisk.
Okay, thank you.
So those are the giants of the criminal procedure revolution. And so I set about writing about them and to show what my research showed, that the court wasn't this counter-majoritarian hero. And on the backside of that project, I thought, well, maybe I just haven't found unpopular enough people. Like maybe I just haven't found the unpopular minority. And so I started thinking about it and thought, yeah, capital defendants, right? Death row inmates. You want unpopular? You've got it, right? Hated for legitimate reasons, right? Despised, universally poor, disproportionately from Black and brown communities. And so I thought, all right, I'm going to do a legal history piece on Furman versus Georgia. And that was the Supreme Court's big decision in 1972, actually ruling that the death penalty as then applied was cruel and unusual. You know, a lot of people don't know that the Supreme Court actually invalidated the death penalty in 1972. We didn't have a death penalty. This country did not have a death penalty from 1972 to 1976. And it was seen, you know, the aura was, oh, you know, you've got the Burger Court and they, you know, protected, they saved all of these lives. They protected the most unpopular minority in the country. And so I thought, all right, that's the one. Surely the court played the role there. And so
that's the ticket right there. Yeah.
Right. I wrote that piece and was like, no, it didn't. But that was my first death penalty piece. And the thing about the death penalty is you start writing about it, it's really hard to look away. It's like this train wreck and you just can't stop. And so, you know, that started sort of a lifelong, career-long interest in the death penalty on the merits and its interaction with Supreme Court decision-making.
Could you explain what happened between 72 and 76? So in 72, the court nationally says no more death penalty. And then in 76, the court comes back and says, okay, you can start again. What was that? What happened there?
Is it okay to say all hell broke loose?
Yes. On this podcast, you can say anything you want.
All right. Well, that's exactly what happened. So in 1972, in Furman versus Georgia, the Supreme Court said that the death penalty, which this was clearly true, the death penalty was applied in an arbitrary and capricious manner.
Yeah.
And so the court said, you know, you could put these cases right next to each other, and there's no way that there is any logical distinction between who is getting death and who is getting life. And so the court said part of the problem was that juries just had unbridled discretion. They could do whatever they wanted. And they did. They did whatever they wanted. So the Supreme Court struck down the death penalty.
Which I assume meant most of the time putting black people to death and not putting white people to death.
Yes.
Yeah. Okay.
Yeah. I mean, that ran through 3 of the 5 justices' opinions in Furman. So here's a little fun fact for you, Eric. At the time, Furman versus Georgia was the longest decision ever to grace the United States reports.
Didn't know that.
I don't think I think some other case has eclipsed it. And if I remember correctly, I might be off, but I think it was something like 236 pages.
Wow.
But that's the number that's in my head anyway. But every justice, all 7, wrote an opinion in Furman versus Georgia.
Wow.
And one of the things, getting to your question, is that the 5 justices in the majority each wrote a concurring opinion. There was no plurality opinion. There was no majority opinion. There was a 1-paragraph per curiam opinion that was, I think, 3 lines long that just said, you know, for the reasons below, these death sentences are invalidated.
Right.
But so the 5 justices in the majority wrote, it was a 5-4 decision. The 5 justices in the majority each wrote a separate concurring opinion, and no justice in the majority joined another justice's concurring opinion.
That's crazy.
So you had these 5 concurring opinions. And by the way, it was quite remarkable because 2 of those justices were Justice Stewart and White.
Right.
And they were known as the great dissenters in the Warren Court era. These are no liberals here. And they went ahead and voted with the majority in Furman. In fact, they were a necessary part of the majority. So you had this very splintered decision. Part of the reason and the backstory of that is that the justices really thought that the death penalty was on its way out anyway.
Right.
And in fact, I think it's Stewart that ends up saying, you know, a vote the other way would just delay the inevitable. And so they think it's on the way out. You know, you know this as well as I do. You know, I think of the Supreme Court often as the leader of the band, but sometimes the band turns left and then the leader runs and gets in front again. Yeah. That was the court in Furman. And so they strike down the death penalty thinking the country is done with this. By the way, in 1972, when they had done that, the country had not had an execution since 1968.
Wow.
So,
I didn't know that
it had
either.
no more
Wow.
executions, death sentences were falling. I hope we'll get a chance to talk about history repeating itself, because that's happening again.
Yes.
But so they strike it down, they think it's dead. And what happens? But the states, 35, 36 states pass statutes revamping their death penalties and bringing the death penalty back.
I've got to ask you, Corinna, because this is, and you know my work as well as anybody, so you know what
I sure
you,
do.
You know where this question is coming from. Had the court stayed out of it, do you think it would have ended up differently? Because that's how I feel about abortion, as most people know.
Yeah, I do.
Wow.
Yep.
I've never heard this before about the death penalty. Wow.
Yeah. And in fact, so the legal history piece that I did on Furman was a piece on Furman and Gregg, the 1976 decision. And so I got into the original sources. You've got Time Magazine, Newsweek saying, the death of the death penalty. Everybody's talking about it. One of the news magazines on the backside of the decision says, we issue a collective yawn at the decision.
Wow, I didn't know that.
Because it was so obvious that this is where it's going, that it's on its way out anyway. All of these states had abolished, so that's where the court thought it was going. But instead, it inspires a backlash.
Yep.
One of the greatest backlashes in the history of the Supreme Court, certainly along with Roe.
Yeah.
But it inspires I think the biggest legislative backlash in the history of the Supreme Court.
Wow.
You had certain states where the citizens and the legislature demanded to bring the death penalty back in the wake of Furman, and that state had already abolished it.
Corinna, I have to interrupt for 1 second, just because I didn't know any of this, so I've already learned more in 5 minutes than I. But I do want to make an editorial comment about this, because Reva Siegel at Yale, no relation, who I respect a tremendous amount, and Linda Greenhouse, who has been on this podcast, who I respect a tremendous amount. I disagree with them so much about the backlash about abortion, and one of the reasons I do. I'm just going to take this 1 minute. They claim it would have happened anyway in the legislatures. And I keep saying to them, no, you don't understand. It was a double whammy. It was, yes, abortion was divisive, more than death penalty, but they didn't want to be told what to do by 9 lawyers sitting in Washington. And that's the middle of the country. And that's what law professors, this is going to get me in trouble, like Reva, don't understand. That this country is about Ohio and Oklahoma and Missouri and, as much as it's about Boston. And the story you're telling me is a story of abortion as well. And I didn't know this story. So anyway, I'm sorry. Go ahead.
Yeah, it absolutely is.
Go ahead.
It absolutely is. And, so I think this is remarkable. In 1972, Nixon is running, right? In 1968, he wins the presidency on a law and order platform, which, by the way, was largely a response to the criminal procedure giants that I mentioned at the beginning, right? So you see this intersection and politics playing off in backlash politics to the Supreme Court.
Yep.
He runs again in 1972. The death penalty is so dead that Richard Nixon, who was law and order, does not campaign.
Wow.
He is silent. The platform takes no position. The Republican platform does not take a position on the death penalty in 1972. They're quiet. The Democratic platform is in favor of abolishing it.
I'm not sure they had a platform on abortion either. I'm not sure about that. I have to go back and look.
I'm not sure
I
either.
know it was not a big issue in the 72 campaign. That I do know. Of course, Roe hadn't happened yet, and that's one of the reasons. Anyway, go ahead.
Yeah.
Yeah.
But, so many of these states that were getting there anyway. And like I said, to have a state say, we want this back, the Supreme Court took it from us.
Right.
And it's like, you didn't have it. You had already abolished it. This wasn't about the death penalty. This was about not being told what to do.
Yeah. I know. Well, see, that's okay. This is awesome. I'm having Reva on this, and we're going to confront her. Okay, go ahead. Go ahead. Anyway, so that happens for 4 years, and then we get to 76, and the court does what?
So 1976, the court takes more cases under tremendous pressure. By the way, not only have legislatures turned but public opinion has done a 180. And contemporary sources at the time, commentators at the time, saw it for what it was and said, the Supreme Court brought this back.
Wow.
You know, the court's decision in Furman caused the turnaround, caused the U-turn. So they were saying that even at the time. So the court takes these cases in 1976. Everybody knows why the court is taking these cases. It's under tremendous pressure. And yet, there's all this research that has come out in the intervening time about how these new guided discretion statutes did not guide discretion one iota, and it was every bit as arbitrary and capricious as it was before. And not only that, Eric, you're going to love this, but the new statutes are based on the Model Penal Code's guided discretion statute. And the court had said in 1971, right before Furman, that those statutes did nothing to guide discretion.
I actually remember. Yes.
Yeah. So, you know, the court is already on record saying the statutes don't work. There's research showing the statutes don't work. The court has already stated, hey, you can't have the arbitrary and capricious imposition of death. In 1976, the court says the statutes work. And in fact, there's a beautiful footnote in Gregg that I always find really amusing, where the court says, some have suggested that the statutes don't work. And I read that and go, some, as in 4 of you.
So Corinna, was this a example of a 5-4 case becoming a 5-4 case the other way because of a change in personnel? When did Powell?
No, and there were shifting majorities, so there's actually a plurality opinion.
Okay.
And there's a number of different cases, and so it's not quite that simple.
Okay. Sure. Okay.
But
so we get it back. We get it back in 76.
You get it back in 76.
And then, how did we kill people between 76 and whenever lethal injection started? I have no idea when that was. But how did we do it in that time period?
Yeah. There were basically 4 different methods. So you had shooting. Mm-hmm. And by the way, the very first execution in our country, which was before we were a country, when we were still a colony, it was in Virginia, and it was death by shooting. So like shooting has been around for a really long time. But generally it was hanging. Yeah. And then in order to be more humane, it moved to the electrocution, the electric chair. Right. And then there was some flirting. I mean, some states had the gas chamber. So you had those 4. Right. And all of them produced gruesome, terrible deaths. And so, you know, to your point, one thing that's really interesting is when you say, like, well, when was lethal injection? When did they adopt that? That was 1977. Wow. The year after the Supreme Court brings the death penalty back in Gregg. And I'm writing a book on it. So, you know, there's going to be some legal history in there. But what's interesting is that the legislatures around the country said, it's 1977. We have not had an execution. This country has not seen an execution since 1968. It's been 10 years. And the country is queasy. This is a new death penalty. We just brought it back. I don't know that we haven't been executing in 9-10 years. And I don't know that people are ready to see electrocution, to see more gas chamber. These are terrible deaths. We need to do something to make the death penalty, to tame it, to make it look more acceptable. And they talked about it in those terms. So
we're going to come back eventually to Virginia and what happened in Virginia. But before we do, I want to jump to history now and talk about our mutual friend Eric Berger, who's at Nebraska, who's a great guy. He wrote a piece once.
Great guy.
He once wrote a piece about actually administrative law, which you have too, but talking about lethal execution.
He read my piece, by the way.
Yes.
No way I would publish that without his eyes being on it.
I do that with most of my pieces with Eric. But anyway, so what fascinated me about everyone knows I'm a big proponent of deference for judges to others, although not in criminal cases. But leaving that aside, the horror story he told about Kentucky and who was actually responsible for lethal injection in Kentucky is of a piece with your piece, which talks about the people who are making these decisions. Present day, let's forget the history for a minute. Today, who is deciding these cocktails today?
Yeah, well, generally, the people deciding it are lawyers.
That's insane.
It is so insane. And not only is it insane, but it's lawyers doing Google searches.
You're killing me here. I shouldn't use that phrase.
Yeah,
But
and I have to say that's so unbelievable that I just want to say I brought the receipts. Like I can show everything. But yeah, and here's the thing: when Oklahoma adopts the first lethal injection statute,
yeah,
it goes to the DOC and
wait, DOC.
the
I'm sorry.
Department of Corrections.
DOC is what? The DOC.
Department of Corrections.
Yeah. Okay. Right.
And those people, they're experts in prison security. I assume they're great experts in, death row. I'll give them all of that. But they are not pharmacologists. They are not anesthesiologists. They don't know. And so what do? Well, they reach out to various medical boards, the state medical board, some other people. Nobody wants to play because of medical ethics. And so they find someone to talk to, and it is the Oklahoma's medical examiner, a coroner, who says later, I'm an expert in dead bodies, but not in getting them that way.
Oh my God.
And he makes it up. He makes up the 3-drug protocol
How do we allow
off
this?
the top of his head.
How do we allow this?
He's later interviewed, and they say, I think Debbie Deno talks to him, and of other people too. But and he's asked like, wait, you didn't do any research? And he said, no. And it was like, well, what, like, why not? And how did you come up with it? And he said, I've just been under surgeries, so I just kind of, made it up. And he said, I didn't do any research. The Department of Corrections adopts it because they don't know what to do.
Right.
They don't know what to do. And every other state, the states are now passing these lethal injection statutes. And those DOCs, the Departments of Correction, they don't know. So what are they going to do? They're going to follow Oklahoma.
Right.
So later, this guy, Jay Chapman, who's the coroner, says, I never in my wildest dreams would have believed that something I made up off the top of my head would mushroom like this. He said, I guess they just blindly followed it. That is the origin story of lethal injection. Well, some other things happen there too. They get this Holocaust denier, this guy, Fred Lecture, who, tells the Departments of Correction that he has an engineering degree and he's going to build them a lethal injection machine. He doesn't have an engineering degree.
Jesus.
He's later charged with fraud. He has a history degree. And he's a Holocaust denier.
So one of the points. Go ahead. Sorry.
Yeah. No, I was just going to say, so like they'd run through that comes out, that's a big scandal. And then it's like, who are you going to get? And, they don't have someone advising them. They did have this guy, Mark Dershowitz, and the American Board of Anesthesiologists find out that he's advising. And he issues a public statement and says, I will no longer be saying anything about lethal injection to anyone, because anesthesiologists, and they're the people that would really know, right, how to do a painless death.
You'd think?
The ABA, the American Board of Anesthesiology, has said, they've issued a statement and said, if you advise or participate in any way, including advice, we will take away your board certification.
Corinna, I have a couple questions about this whole sordid thing. I'll try to limit it to
But that's how we get to lawyers.
Yes. Well,
That's how we get to lawyers.
But two questions.
Yep.
One, I mean, in relatively modern times, the Supreme Court has looked at this and looked the other way, is my understanding, which is insane to me. Eric Berger's point was this is not a situation where the court is deferring to legislatures or governors or Congress. They're deferring to prison guards, basically, who know nothing about the lethal injection they're given. How did that happen? That's one question. Question two, I've never understood this. I'm actually asked this all the time by people, and I say, sorry, not my area, ask Professor Lain or somebody. But so I'm going to ask you, why can't we just give them enough morphine to kill them? I've known some elderly people, who were at death's door, and they were in a lot of pain. And the answer was, we'll give you enough morphine to cure the pain, which we also know will probably kill you. But that's what you want. The Supreme Court has even blessed that, kind of, in dicta. Why can't we just give them morphine and let them sleep? Is that a crazy question?
No, it's not a crazy question. If you want me to take that one first,
Sure.
I'll just say,
Sure.
I had a similar question. I set out to write a law review article on it. The law review article was called, Why Can't We Get Lethal Injection Right?
Yeah.
And the whole thing was like, wait, we put down cats and dogs by the thousands.
Right.
Every day.
Right.
Right? We put people under and then we cut their chest open. And we do all of these painful things. Why can't we get this right? My little article became a book. I'm in chapter 12. It's a very big book.
Yeah.
This is a very complicated question.
It's a big topic.
But, it comes at the intersection of drugs, the availability of drugs, what drugs they can get, because these are all controlled substances, and you don't have a prescription.
No, but states can use it. I mean, states can use it. They don't need a prescription, do they?
I think they... So the earliest cases, you actually had Texas falsifying, the Texas Department of Corrections falsifying a prescription, saying it was for an inmate at a location that no longer existed. And the pharmacy found out and just refused to fill the script. But whether it's a compounding pharmacy, I mean, these are all controlled substances. You're supposed to have a prescription. Clearly they don't. And then you've got the drug manufacturers. And so one thing to recognize, there's all this stuff about, it's the abolitionists, it's all their fault. They've this is the guerrilla warfare you heard about.
Meaning you.
And I would
you're
say
an
two
abolitionist.
things about that.
I mean, you're an abolitionist. They're blaming you.
Well, two things I would say. Number one, to the extent it's the fault of the abolitionists, those abolitionists have names.
Right.
And the names are Great Britain,
right.
Germany,
right.
Italy, and the sovereign nations of the European Union, who have been fiercely abolitionist for decades. And, it was actually an accident that they came to put these export controls. But that, what happened was one of the Hospira, this major pharmaceutical company, had an aging plant in North Carolina, relocated the plant in Italy, and the Italian authorities said, okay, well, you're not going to, we're not going to license your plant if you're supplying to executioners. We're fiercely anti-death penalty.
Right. And
Hospira decided, I'm just going to stop making it because it's not worth it. And that just sort of started this, the major pharmaceutical companies, they're in Europe.
Right.
We can put export controls.
Right.
And so you see all of this discourse about like the abolitionists, and I'm thinking, we do that all the time. Right? Like we say we're not going to sell to you because we don't like what you do with those products, or we just don't like what you're doing generally.
Right.
Well, guess what? We're on the receiving end of that because of the death penalty.
Right.
And then even for domestic suppliers who you could say, well, okay, that's a lot of the major, big pharma is over in Europe, but not everyone. There's some big pharma in the United States. Their mottos, literally, one of them is drugs for life.
Right. Right.
One of them is, helping patients live longer. I mean, like these, this is like a scene out of The Onion,
Right.
that like they do not want their drugs being used for executions. And recently they've sued
So let me be.
to stop that from happening.
I'm
So that's not abolitionists. That's
Right.
like the drug companies don't want this.
I'm
So
confused.
anyway, it's complicated, but
I'm confused about one
those
thing.
two pieces are important.
I'm confused about one thing about that story.
Yeah.
And we like each other so much that we're laughing, but this is a dead serious topic. I don't mean to be making light of this in any way, and neither do you, obviously.
True.
I'm confused. So Georgia has a death penalty, I think.
Yep.
I think they use lethal injection. I'm not sure about that.
They do.
I don't understand. What doctor is involved in the creation of that lethal injection, if any?
Okay. So there's 2 points where one would want a doctor involved to have a minimally competent lethal injection.
Right.
One is coming up with the drugs.
Yes.
So this is where, and I mean, this was Oklahoma's story. Literally the lawyers, and it's not just Oklahoma, there's other states too.
No, Kentucky. Eric Dick documented on Kentucky also.
But they're getting online. Why? Because they don't have doctors that are willing to play. Okay, so one is advising them on just like the right drugs.
Right.
The other point in time is who's going to actually administer this? Because you're talking about catheterizing the vein. And by the way, death row inmates, they tend to have really bad veins.
Right. Right.
By drug, chronic
Sure.
drug use,
Sure.
health problems. They really do have bad veins. So, you've got that piece of it. And what they're doing is they are injecting them with this huge overdose. So when I started looking at lethal injection, I thought, okay, 3-drug protocol, it's probably 3 syringes, like 1, 2, 3. How hard can it be? No, it's like 12 to 15 syringes.
Oh my.
Because they're doing this massive overdose. And they are paralyzing them so that it looks like a peaceful death. But a bunch of autopsies, and I mean 80% of the autopsies with midazolam, which is the most recent drug, are showing that these people are dying from slow suffocation, from pulmonary edema.
I hate to do this, but since I did read a couple of the cases on this. Take us through. This is painful. So, but take us through. The drug is supposed to paralyze you, put you to sleep, kill you, right?
No. Well, so you've got in the 3-drug protocol.
Yeah.
The first drug is supposed to render you insensate, so that you cannot feel.
Does it do that?
No,
I didn't think
it doesn't. But I think the original 3-drug protocol, sodium thiopental would have, pentobarbital would have.
Right.
They can't get those drugs. So now they've turned to midazolam, which is in the benzodiazepine family. And those are that's Valium.
I was going to say, isn't that just really strong
Xanax.
Valium? Isn't that really strong Valium?
Yes. What do they call it? A martini in
Oh my
a
God.
pill.
Okay, so
is basically what they got. But like, it's a relaxant, and it can. Don't get me wrong. It can put you out. It can knock you unconscious. The problem is it doesn't render you unconscious at a level where you would reach a surgical plane of anesthesia.
Right.
Where somebody could cut you open and you just wouldn't even know.
Right.
Noxious stimuli will wake you up. And that's what we see with the botched executions. Noxious stimuli will wake you up. So that's the first drug. What's the noxious stimuli? It's the second and third drugs. So the second drug is the paralytic.
Right.
And pancuronium bromide. And it, the idea is that it's just, the Supreme Court has said that the state has an interest in a dignified death.
Yeah.
But that dignified death, that is to the benefit of the state. It is certainly not to the benefit of the inmate. And in fact, it does 2 things. Number one, if the first drug doesn't work, which we know pharmacologically, midazolam does not work. Right. There is no question about this. This is a scientific consensus.
Right.
But if it doesn't work, no one will know because you're paralyzed. But the second point is, as it paralyzes you from the outside in. So the last thing, so first, you start looking at it's also a muscle relaxant. So you look nice and peaceful,
joy.
right? You don't paralyze,
Right.
like that, like you're paralyzed with a very peaceful look. But the last thing is the diaphragm. And so as it slowly freezes, your breathing becomes more and more labored. You have to work harder to actually catch your breath. And so in these autopsies, they're seeing bulging veins where on the inside, these inmates, they are definitely awake and they are definitely suffering from air hunger. They're trying to catch their breath.
Like drowning.
And if you think about it,
Like drowning?
this is happening over 15, 20 minutes. In the Lockett execution, it was 45 minutes. That is slow suffocation while being paralyzed. So the anesthesiologists that are testifying are saying, look, this is like being buried alive. Like you can't even scream out in pain. You can't move.
You're scaring me here.
But
okay.
all of this is happening.
Wow.
And then the third drug is the one that's supposed to bring a quick death. That one is known as liquid fire because it chemically burns the veins as it races to your heart and causes a cardiac arrest. So like these are terribly painful drugs.
Okay, so all right.
Yeah.
So that was depressing.
So on that note, that was depressing.
So
there was a prior question you had asked.
That's right. I want to move on. I want to
it.
move on to something because I'm sure there are some people listening to this, and maybe a lot of people even, assuming a lot of people listen to this, which is a big assumption. That all right, but these are terrible, heinous, awful human beings, and even if we don't want them tortured, a little bit of suffering at the end isn't bad, given all to get the death penalty, the terrible things they've done. And you wrote a piece. This piece almost made me cry. Called, I don't know if it's the title, but "The Worst of the Worst." And your point is, we are not killing the worst of the worst. Can you explain that?
Yeah. So if you look nationwide, and that particular little essay was looking at Virginia as Virginia repealed its death penalty, and we were saying goodbye to it. It was like, who was Virginia actually executing? And so in that little piece, I looked at who Virginia was executing and said, this is the same thing that's happening nationwide. So who are we executing? Number one, who we're executing are people with serious mental illness. And by that, I mean, that's not just a colloquial description. That's serious mental illness, SMI, in the latest DSM-5 manual. Okay, It's a diagnosable serious mental illness. And these people are diagnosed. So, for example, the very last person to be executed in Virginia was a guy named William Morva, and he was actively psychotic. He thought, and I mean, this was true even at trial. This was true even as he committed the offense. So this isn't necessarily something, I'm sure it got worse when he was on death row, because all mental health and mental illness, it's very bad for you to be in solitary confinement.
Yes.
So like anything they come in with, it gets worse. But, even at the time of the offense, he thought he suffered from this rare intestinal illness that required him to eat large amounts of raw meat and pine cones. He thought his real name was Nemo.
Wait,
that
pine
he was
cones?
Sent to
He ate pine cones?
Yeah.
Okay.
I mean, he was actively psychotic. And it's like, is that person the worst of the worst?
Right.
I mean, the death penalty, the Supreme Court has said it's not for any murderer.
Right.
It's for the worst of the worst murderers.
Right. But it's not. It turns out it's not, though.
No,
Yeah.
It's not. And I think other categories, it's for, and Steve Bright wrote the landmark, piece on this,
Right.
but it's for the worst lawyer. Death penalty, not for the worst crime, but for the worst lawyer. So we see that. It's for people who have the bad luck of being in the wrong jurisdiction, where you have a Commonwealth's attorney or a state's attorney that wants to go whole hog on death.
Right.
And there are the deadliest counties in the country, our death penalty is a 2% death penalty.
Yeah.
2%
Right.
of the jurisdictions really account for our death penalty, right? You think it's states, but it's
Right.
really jurisdictions. And then, of course, those who commit black on white crime.
Right. Well, so on that point, I've never told you this, but I was a law clerk in Northern District of Georgia from 83 to 85. And Judge, I'm having a senior moment on his name, who had the district court case in McCleskey versus...
Oh, Kemp.
Yeah, so...
McCleskey versus Kemp.
Yeah, their
wow.
His law clerks came, I was friends with them, and they came to my I was going to say my chambers, Freudian slip, my little office outside the judge's chambers one day. I think it was towards the end of my clerkship, and they were in tears, both of them. And both, by the way, were reasonably conservative. They were in tears because the data was so overwhelming. And they knew two things. They knew that the data about who gets the death penalty for what was so racist, and they knew they were never going to win the Supreme Court. And it was a devastating afternoon. Why don't you tell everybody about that case and what happened? Because it's a biggie, right? I mean, it's...
Yeah, well, in McCleskey versus Kemp, they had just a ton of data. They had the very famous study called the Baldus study.
Right.
And it was David Baldus and some associates. They collected data, and they actually managed to account for over 230 non-racial they took out everything.
Right.
And said, when you take everything away, strip every other possible reason away, all you're left with is race.
Yep.
And a black defendant who kills a white victim is over 4 times as likely to get the death penalty. And there was no other explanation.
That's what they said. That's what they said. I never forget it. They were so sure.
Yeah.
But the Supreme Court...
Yeah. And so one sort of... I hate to say fun fact because there's really nothing fun about this topic. But one of the interesting things is Powell writes the opinion. It's a 5-4 decision. And, in dissent, the dissent in that decision says, look, in Furman versus Georgia in 1972, you said it couldn't be arbitrary and capricious. You said, this is Furman, but with proof.
Quick aside. Yeah, quick.
But one other thing I'll just say is that Powell, after he retires, his biographer says, "Do you have any regrets?"
I know.
You know it. Do you want to finish it?
Well, my understanding is he said Bowers versus Hardwick.
No. Well, he might have said that too, but in this biography, he said McCleskey versus Kemp.
He had a lot of regrets for a guy.
Regretted his vote.
He had a lot of regrets for a guy who voted the wrong way a lot of the time. What I wanted to say about Powell was...
True.
Because Virginia, you've spent most of your career in Virginia, and what Justice Powell might be even more famous for than his opinion, his statement that Bowers was really bad, and I wish I hadn't done it. And McCleskey is he brought commercial speech and corporate and protection for corporations to the Supreme Court in the early 1970s in a way that has done unconscionable harm, in my opinion, and eventually their decisions united in all those cases. He was a very nice man, apparently, and a Southern gentleman, but boy, did he do a lot of harm. I mean, did he do a lot of harm? Anyway, going back to McCleskey, what was the majority's rationale? I don't even know. Why did they deny this? These statistics were so clear.
In that particular case, what they basically said was, they said a couple things. One of the things they said was, you've shown this disproportionate impact.
Right.
That's not enough.
Intent. You got to show intent.
You have to show in your case, which it's like, what does that look like? I think I'm going to charge you because you're black. Okay, good luck finding that sort of evidence. But that's what the court said. And one of the things that the dissent said was, the sort of evidence that will save your job is not enough to save your life.
Oh my goodness!
Right, and it was true. It was true.
And I forgot one thing I meant to ask you about lethal injection. Yeah. In the article that you wrote, and then we're going to. And by the way, for those listening, we are going to move to some better news in a minute because this has been very depressing all around. But I think I read in your piece that the way we put down dogs and cats is way more humane than the way we put down people. Is that right?
That's true. Yeah.
What kind of society does that?
And the Supreme Court, like that argument has been before the Supreme Court. That was in Bays. So Bays versus Reeves, which was the first lethal injection case. So the states, almost all of them actually regulate how, this is state legislatures, so statutes on the books, actually regulate how veterinarians can put down dogs and cats. What do they call that? Well, they say it's not domestic animals. Sometimes they'll say that, but they'll say, I don't know what they say. Something about basically like non
wildlife,
cattle. Anything else that's not cattle. In any event. So, these statutes actually regulated, and everywhere that it's regulated, you cannot use a paralytic in a death of a cat or dog. And that's because you're both doing something painful to them. Okay. So they are dying by slow suffocation, and you are hiding pain. So you can't monitor it. You can't do something. They won't cry out in pain. And, that argument was before the Supreme Court, and actually one of the justices who concurred, so I'm like, well, you went along with the decision.
Right.
But one of the justices said that it was unseemly that Kentucky was executing prisoners in a manner that it would not allow on the prisoners' pets, on their pets.
So I'll try to tell the story without getting emotional, but we had a 16-year-old lab who we loved. My wife Lynn loved this lab so much, and we had to put her down.
Is that McSweeney?
No. This is the pre-Sweeney dog. This is Daisy.
Okay, Sweeney.
But real quick, they came to our house to do it because Lynn wanted it to be done. And it seemed like the most peaceful thing I've ever seen. And I don't know what's inside poor Daisy's head, but I'm pretty sure she didn't suffer. And I just can't imagine how we live in a country where we make human. I understand the dog did nothing wrong and the prisoner did, but that isn't the point. The point is we have a way of doing this without pain. All right, we don't have that much time left, so I want to get to the good news. So talk to us about Virginia. The first state to use the death penalty, the state where there's been more, I think, executions than any state in the country, including Texas, which I learned from reading your work, which I couldn't believe, but okay.
Well, Virginia had a 400-year head start.
Fair enough. That's fair enough. Still, it's Texas.
So there's that.
Still, it is Texas. What happened in Virginia, and how did they get rid of the death penalty?
Yeah, well, I have to say it was. The story is much larger than the one that I'm telling in this particular piece.
Sure.
The piece focuses on the impact of having regional capital defenders, but I mean, before there were regional capital defenders, there were very, very good appointed defenders. There was various groups doing various work. And then there was a lot of abolitionist groups. So I want to say, and it's really important to understand this, that it takes a village, and there was no one, I don't even think there was one tipping point. I really don't.
Interesting.
You could have all of this going, and if you didn't have a blue legislature and a Democratic governor, that wasn't going to happen. So, and in fact, Trump and his zeal for executions, even as a lame duck president, that contributed to backlash. There was all kinds of things in there, but one of the stories, one piece of that is the role of having regional capital defenders. And the fact of the matter is that in 2021, so Virginia just repealed this past spring, but in 2021, we had not had a new death sentence in 10 years.
Right.
We had not had a new one. The death penalty was dying on the vine. It was already gone. And we only had 2 people on death row.
Right.
And we only had 2 people in death row in part because Virginia was really, really good at executing people. Virginia had, in my mind, the skimpiest, most indefensible appellate review of death sentences in the entire country,
Wow.
which gave it the ability to turn death sentences into executions at 5 times the national average.
Wow.
I mean, Virginia's like way off. And it had the fastest death penalty, and it had the broadest death penalty statute. And that's not just me saying that. Like, that was a Columbia study that said, Virginia has the broadest death penalty statute in the country. So, when you think about it, a lot of the press for Virginia has been on, it's the first Southern state to abolish. And, fair enough. And yes, although, Virginia has gone from reliably red to purple to blue, and it's not so much acting like a traditional Southern state.
I understand.
And so, yes, it is the first, and I don't want to take away from that, but I think there was a lot of other things going on. What I think is more remarkable than the fact that Virginia was the first Southern state is the fact that this was the strongest, most lethal death penalty in the country.
Right.
Now, how the regional, the role that the regional defenders played in that is I mean, it takes me 92 pages to tell that story. It's really long, but I'll just say it came with independence. They weren't court appointed, so they could be a real pain in the butt. They didn't care about the judges' calendars, because they didn't have to look to see if they were going to get appointed on the next case, right? It brought resources in-house, so they weren't asking the judge for somebody to be appointed. They weren't asking for more hours, asking for more money. They had all that in-house. It allowed for efficiencies. It connected them into a national organization where they went to national trainings, picked up tactics, brought it back to Virginia. So there were all kinds of things that happened when that happened. But again, it's one piece of a larger story.
So I'm going to I have one last question for you that you can refuse to answer if you want. The background is this. From what I've learned from you today and from reading your work, which I love, is one, the death penalty, which I already knew, is racially biased in all kinds of ways. Two, the way we kill people is horrific and almost certainly cruel and unusual punishment, if there is such a thing.
Clearly.
Three, we don't even execute the worst of the worst. We execute people who are mentally ill and who really should probably be getting help in a confined place, we would agree, but getting help. With all three of those things, I think it is extraordinarily clear, it should be clear to almost any sensible person, this country needs to stop using the death penalty. But here's my question for you. And just to give people listening some background, you were in the military. I know what your politics are. Describing you as like a knee-jerk, bleeding heart liberal would be completely unfair. That's not who you are. First of all, because you're much more thoughtful than that. But that's just, you're not a Massachusetts bleeding heart liberal like I am. That's not who you are. If we could do it in a way that was not racially biased, that wasn't cruel and unusual, and we did execute the worst of the worst instead of not executing the worst of the worst, would you still be against the death penalty, both personally and professionally? And you can take the fifth if you want.
Yeah, no, it's okay. So I wrote a piece several years ago where I really came out with my own views. It was a very personal piece, and so I can share that here. Yeah. Although I will say that doesn't generally animate any of my work. I have people all the time saying, like, so are you for it or against it? Like, because you're it's not really advocacy work. And I have to say, on a personal level, I would oppose the death penalty, but for reasons that I actually don't believe belong in the public discourse. It's a matter of faith.
Right.
And I am a staunch supporter of the separation of church and state. And so, I look and say, if the reason comes down to you need to believe like I do, well, then that's not something that that I think our policies in a pluralistic society
Right.
should be based on. Hello,
Right.
abortion also. But
Right.
anyway,
Yes. Yes.
but here's the thing, the question that I often ask is saying that someone deserves the death penalty is one side of the equation. And you can look at some of I want to own that, right?
Right.
Like I want to acknowledge that some of these are horrific murders. And to look at someone and say, which, I don't think many of them do, but, to look at someone and say, okay, but you deserve the death penalty. That's one half of the equation. And the public tends to stop there. But there's a second half of the equation that in my mind is always determinative. And it is, okay, you might deserve the death penalty. State, have you done what you deserve, what you need to do
Right.
to deserve to take that life?
Right.
And the answer is universally no. And it will never be yes.
Right.
Because among those things is competent counsel that we pay for. And we still don't do that. And where we do, hello, Virginia.
Right.
Where we get good counsel in there consistently, we had good counsel before, but like where you bring this stuff in, the death penalty goes away. The death penalty melts away.
Right.
Because they're able to tell the juries, really, is this guy the worst of the worst? Look, we're not talking about letting him out. Not
Right.
ever.
Right.
Right? They're
Right.
not safe.
Right.
But is this guy the worst of the worst? Is that guy? Is that guy? Is that guy?
Right.
And when you can make that argument, the fact is there just aren't enough people left that really are the worst of the worst to sustain an entire
Apparatus.
death penalty structure.
Yeah. All right.
Just doesn't exist.
That's a
Hey,
great
I know we're going to run out of time.
Yeah.
So one thing I wanted to kind of, by way of a note of good cheer,
Okay.
is to give you a little bit a sense of what's happening with the death penalty nationwide.
Go.
Can I do that?
Yes, go. And then I'm
Okay.
going to end this by embarrassing you, so I'm warning you in advance. Go ahead.
Okay, whatever. In 1999, and I went 1999, 2009, and 2019. I didn't want to use 2020 stats because COVID, and I think they're skewed.
Sure.
But they're low.
Yeah.
1999, 279 death sentences. 2009, 118.
Wow.
2019, so 10-year increments, 34. Nationwide.
Well, that does make me feel much better, Corinna.
Executions. 1999, there were 98 executions. 2009, 10 years later, 52 executions. I mean, this is dropping dramatically. 2019, 22.
Wow.
And 8 states have abolished the death penalty legislatively on their own in the last 10 years.
So lesson is Supreme Court, stay away? It's not,
So, I think part of those, I look at those lethal injection decisions, honestly, and I look at the court as a very frustrated court. They like democracy. They like saying, oh, let's not get involved, except when it doesn't go their way.
Of course.
And this is you look at those decisions and you're like, yep. You can tell their posture. It's almost like their body posture.
Yep.
They're on the defensive because they know this death penalty, it's dying.
Excellent. Well, we're going to leave the death penalty right there and hopefully in 5 years. I do want to say something to those listening. You need to read Professor Lain's work and not just on the death penalty. Shortly after we met, shortly after we met, you completed an article, I don't know if it was Stanford or California, I forget which law review it was. I think it was one of those two, about the school prayer cases. We're changing subjects.
Yeah, Stanford.
Stanford.
It was a Stanford thesis.
And you told me what the thesis was, and I was like, nah, no chance. And what you told me was the most controversial cases ever decided by the United States Supreme Court, including abortion, Brown, everything else, are not Roe and Brown or anything else like that, but were the 1962 and 63 cases where the Supreme Court held prayer in school were unconstitutional. You told me that, and I was like, okay, that's interesting. I'll go read that piece. I'm not going to believe it. I barely knew you then. And then I went to read it, and I thought, oh my God, not only is she right, but the best thing about this scholarship is that Corinna's saying something that no one else has ever said, or almost no one else has ever said. And to do that in our field is unbelievably hard and difficult. And I liked you before that, but after that, I really understood how special you were. So I want people.
You're such a good friend. So you all need to know the Admiration Society goes right back.
Okay,
and I know it's not supposed
it's my
to be
podcast,
like this,
so you don't get to say any of that. Anyway, thank you so much for doing this. I want people to read your work. You actually make a difference in these areas like death penalty and stuff. And it's really important. And I wish we had 3 hours to talk, but I suspect others might not wish that. So
this went by in 5 minutes.
I know. And
thank you so much for having me on.
I loved it. And,
really a
and
pleasure.
I think it's close to 60, and it felt like 5. You're right. So, thanks, Corinna. I really appreciate it.
Thanks.
Bye-bye.
Bye.
Bye.